ሰላም ጤና ይስጥልን ውድ የኢትዮጵያ ስኩል ኦፍ ላው ቲዩብ ቤተሰቦቻችን እንደምን ቆያችሁልን? ዛሬ በክሪሚናል ፕሮሲጀር ይዘን መጥተናል። አብራችሁን ቆዩ።
Considering setting justice in motion, justice will be set in motion upon accusation or complaint, as we said last time. So an accusation or complaint is necessary for justice to be set in motion. So we said generally accusation or complaint means nothing but it's a process of reporting the commission of an offense. Accusation or complaint is a process of reporting the commission of an offense. So whenever a person, after witnessing the commission of an offense or after getting information about the commission of an offense, reports to the police, okay, about the commission of an offense, we say an accusation has been made. Technically speaking, accusation and complaint are different. We use complaint to refer to, the process of making an application, the process of reporting the commission of an offense in respect of crimes that are punishable upon complaint. We said, in respect of, there are crimes that are punishable upon complaint unless the victim or his legal representatives report the commission of an offense to the police, then police investigation will not continue. Okay, so reporting the commission of crimes punishable upon complaint, reporting the commission of crimes punishable upon complaint, okay, by the injured person or by those deriving rights from that injured person is known as a complaint. Is known as complaint, okay? So complaint is also reporting the commission of an offense, but it is technically different from accusation. But accusation is the reporting of the commission of an offense in respect of other kinds of offenses, other than those crimes punishable upon complaint. And we considered that reporting the commission of an offense or making an accusation or complaint is a right, as we said. Making an accusation or complaint is a right. But there are some exceptional cases whereby reporting the commission of an offense or making an accusation or complaint becomes a duty. These are in respect of very serious offenses that put the integrity of the state as a whole at risk. In respect of these very serious offenses, reporting the commission of an offense is, as we said, it is mandatory. We also said that making an accusation or complaint has formality requirements. It has formality requirements. Okay? So the person who makes an accusation or complaint has to avail himself or herself at the police station. He has to, or she has to physically present and sign and date on the accusation or complaint. Sign and date on the accusation or complaint. It is a duty to physically present and sign and date on the accusation or complaint. And we questioned the wisdom behind these requirements. We said physical presence and signing and dating is important to deter false accusations. Okay, one purpose is to deter false accusation. And we also said that in some exceptional cases, anonymous accusation is allowed. Anonymous accusation under Article 14. Anonymous accusation is allowed. Okay? So, it is not in respect of all kinds of offenses that anonymous accusation is allowed. It is only in respect of some kinds of offenses. Article 12, as you remember, in respect of offenses which disclose serious breach of the law, and are on the face of them circumstantial and credible, anonymous accusation is possible and police will proceed to investigate. Otherwise, anonymous accusation is not allowed unless they refer to serious breach of the law. Anonymous accusation is allowed. So your identity should be known. Your identity should be known. All right. And making false accusation is criminal. making false accusation is a criminal act. So today we will see setting justice in motion in flagrant cases. So before that, we will consider what flagrant offenses are. And in flagrant offenses, a bit different, a bit different modalities, adopted in the criminal procedure code. Okay, in flagrant offenses, there is no need of making an accusation of complaint. There is no need of making an accusation, no complaint. There is no need of making an accusation. So whenever a flagrant offense is committed, there is no need of making an accusation. Okay? No need of in flagrancy. In the case of flagrancy, there is no need of making an accusation. And what is the justification behind that? We will try to look at that. And before that, what do we mean by flagrant offenses? We will briefly consider the criminal procedure code under articles 19 and 20. Okay, read article 19. But flagrant offenses are under article 19. Okay, who will read article 19? Volunteer. The elements, article 19, flagrant offenses. So article 1, an offense shall be deemed to be flagrant where the offender is found committing the offense, attempting to commit the offense, or has just committed the offense. So it's found, the offender is found committing the offense, attempting to commit the offense, or has just committed the offense. So if these things are fulfilled, then that offense is a flagrant offense. Flagrant. Okay, it's a flagrant offense. The offender is found committing an offense. So if it's theft, for example, like there's a pickpocket, for example, coming in, just trying to take my mobile from my pocket. He was found. He already took it. He already took my mobile from my pocket. So he was found committing an offense. He has committed it, and he was found just committing the offense, or attempting to commit the offense. And he was preparing. Like there are some people, actually, all criminals, unless he's mentally unsound, make preparation before committing an offense, isn't it? Committing an offense requires preparation. And a pickpocket, for example, before stealing mobile or any property, checks whether your attention is somewhere or not. Okay, whether you are alert or you are sleeping on the day. Okay, so if he looks that you are not around there, you are thinking about something, like sleeping. Maybe last time you have drunk something, or you are busy of thinking something. So that pickpocket is so active, just trying to take something from your pocket, he was caught. So he's attempting to commit an offense, it's a flagrant offense. Or has just committed the offense. He has already taken it. While taking, he was not caught. During committing an offense in the process, he was not caught. But immediately after taking, and maybe he was trying to hide somewhere, he was found. So people might have seen him. He was found by the public, or by a certain individual, or by two or more individuals. But he was found committing an offense, attempting to commit an offense, or has just committed the offense. In such cases, it is called flagrant offense. And what's a flagrant offense? After it has been committed, the offense has been committed, chased by witnesses. Okay, let me review. An offense shall be deemed to be quasi-flagrant when, after it has been committed, the offender who has escaped is chased by witnesses or by members of the public or when a hue and cry has been raised. Okay, so mind the requirements. Okay? After it has been committed, the offender who has escaped, he has already escaped, but chased by witnesses or members of the public, as they have taken something or he has done something wrong, and he has escaped, but he's chased by, people have witnessed him and they are following him. He is chased by witnesses or members of the public, and a hue and cry has been raised. After an offense has been committed, the offender has already escaped, and hue and cry has been raised. Hue and cry, like crying, calling people for help, crying and calling people. Oh, after an offense has been committed, it is common to hear such kinds of cry for help, a hue and cry. So in such cases, then the offense will fall under quasi-flagrant offense. Okay? So technically they are different, but there are some commonalities. Okay? So in this case, the proximity between the commission of an offense and the time that the offender is found committing an offense is very small. Very narrow. You see, he was just found committing an offense. In the process of committing an offense, he was found. Public has witnessed. People observed him. People found him committing an offense, attempting to commit an offense, and he was choosing favorable condition of committing an offense and prepared. But whenever just he starts the movement, towards the offense, he was found. It's an attempt, assuming. The definition of attempt. And just has committed the offense. Just immediately. No longer time hasn't lapsed. Okay? He was found just committing an offense. So it is flagrant offense. But in this case, after the offense has been committed, was that flagrant? After the offense has been committed, the offender who has escaped is chased by witnesses. He has already stolen, or he has already done something wrong. He has already committed that offense, and he was chased by witnesses. If he is chased by witnesses or members of the public, after it has been committed, then it is called quasi-flagrant. Or a hue and cry has been raised. After the offense has been committed and the offender has already escaped. Maybe nobody tried to stop the commission of an offense. He has already escaped, but a hue and cry has been raised. People usually make this sound immediately after an offense is committed against them, isn't it? Immediately after noticing that an offense has been committed on them, they cry. So, in such cases, a hue and cry has been raised. So people will gather, it's obvious, people will gather. So that kind of offense is also called as a flagrant offense. Please. Sorry? Not necessarily. He shouldn't necessarily be caught. What matters is, he is chased by witnesses. Okay? He has been chased by witnesses or members of the party. He might have escaped. If he is caught, it is fine. But he might have escaped. But he was witnessed by the public. That's a very big thing. He was witnessed by the public. In this case, even he may not be witnessed by the public, but a hue and cry has been raised, and the public has gathered on that place, and has got information about the commission of that offense. He has already escaped. So what matters is the hue and cry. The hue and cry is important because public will gather whenever a hue and cry is raised. Okay, then Article 20, very quickly, Article 20, read Article 20. 20 assimilated cases, an offence shall be deemed to be flagrant and to fall under the provisions of Article 19. So this is as the title tells you, it says assimilated cases. It is assimilated. The cases under Article 20 are assimilated to flagrant cases. They are considered as flagrant. When A, the police are immediately called to the place where the offence has been committed, or a cry for help has been raised from the place where the offence is being or has been committed. So police are immediately called to the place. Police are, after the offence has been committed, police are immediately called to the place where the offence has been committed. Okay? So if immediately police are called, but it doesn't say police should arrive at the place. Simply says police, are immediately called to the place where the offence has been committed. Police is called. So the assumption of the law seems to be that police are called and police have immediately arrived to the place where the offence has been committed. We will see why. Okay. Anyhow, police are immediately called to the place where the offence has been committed. So if I, for example, encounter something and an offence has been committed around here, and if I immediately call the police, then it will turn into flagrant or assimilated case, and it's considered as flagrant case. So the assumption is police will immediately come to the place where the offence has been committed. If police are called and police immediately come to the place, it will be regarded as flagrant offence. And Article B, a cry for help has been raised from the place where the offence is being or has been committed. So while the offence is underway, the commission of the offence is underway in the process, if a cry for help has been raised, then it is regarded as an assimilated case and considered as a flagrant. Being or has been committed just few moments after the crime was committed. Few moments, like 5 minutes or 10 minutes, depending on the case. Anyhow, it hasn't taken too much time. Immediately after the comment has been committed, after the offence has been committed, if a cry for help has been raised, then it is flagrant offence. So the commonality, you don't have to be confused. The thing is that if you look at both Article 19 and 20, flagrant offence, they have common character in that in case of flagrancy, the public will have knowledge about the commission of an offence. The commission of an offence becomes publicized. Okay? It becomes under the knowledge of the public. The commission of an offence, immediately after the offence has been committed, it becomes under the knowledge of the public. So that's what makes flagrant offence. That is what makes that offence a flagrant offence. Okay? Like, for example, if you look at these requirements, both assimilated and the flagrant offences, flagrant and assimilated cases, there is some common element. The commission of the offence becomes under the knowledge of the public. Look, for example, the first one. He is found by whom? By many people. At least by more than one person. He was found committing an offence. He was found by the public attempting to commit the offence. Or he was found after he has just committed the offence. So it has become under the knowledge of the public. Okay? The same holds true for quasi. Like he is chased by witness means many people have witnessed the commission of an offence. They are witnesses or members of the public who are chasing him. That the commission of that offence, information is abundant in this. Information about the commission of an offence is abundant. It is known by the public. The same holds true for assimilated cases. Police are immediately called to the place where the offence has been committed. This means that, people are gathered and people know. The police, it has become under the knowledge of the police immediately. It has become under the knowledge of the police immediately because they are called to the police to the place where the offence has been committed. Okay? And a cry for help, Article 27, Article B. A cry for help. So whenever a cry for help is made, then obviously people will gather to help that person. To help the person who is making that cry. Okay? Immediately it's being, whenever the offense is being or has been committed, immediately if a cry for help has been made, people will run. It means that the public will get knowledge about the commission of an offense. So in this case, that is why Article 21 says, effect as regards setting justice in motion or proceedings or arrest, says, Article 21, the effect of flagrancy is that there is no need of making an accusation. Okay, read Article 21. That is why I said I will come to that point. Very good. I think what makes you to be confused is that Article 20 says it is called an assimilated case of flagrancy. The police are immediately called to the place where the offense has been committed. It means it is an accusation. So what is the difference between this ordinary accusation and the flagrant offense? That is this question, I think, isn't it? So it means, that's why I say, the police are immediately called. In all cases, police are called, isn't it? Whenever an offense has been committed, then you can call to the police for help, for example. You call to the police for help. Crime is being committed in this area. Then, whenever you call to the police will immediately arrive in that area. If police is around, I mean, there is no long proximity between you and the police station, as if the police station is not far. Okay? You may call and police immediately arrive. But if police is far, assume the distance is far between your residence or between the scene of the offense and the police station. So police is already aware about the commission of an offense. You know, police is already aware about the commission of an offense because police has been called. Police has been called. So the main fact of calling the police for help, you call the police not for nothing but for help, isn't it? You are calling the police for help. Crime is being committed or has been committed in this area. So please help. So this makes that offense flagrant offense. But in case of accusation, as we considered, there are procedures. Like, for example, after all, it is reporting, isn't it? You are reporting the commission of an offense, and your intention is a criminal proceeding should be instituted. But here there is the element of reporting. Indirectly you are reporting, but at the same time you are also asking the police for help. And unlike accusation, police will come to the place, isn't it? In case of accusation, whenever you call to the police, then police will come and you will be required to physically avail yourself to the police station, isn't it? And then after that, after recording that, and after requiring you to sign and date, then police will start the investigation. But here that is not. You know, police will come immediately to help and maybe to avert the danger. Because, you know, maybe it's an arson and fire is set, or, you know, people are quarreling, or some hooligans are disturbing the area, or what have you, you know. So police will immediately come to the place and police is called. So the main fact of calling to the police makes that offense flagrant offense because it has become under the knowledge of the police. It has become under the knowledge of the police. You have called the police. But in case of accusation, the formality requirements are necessary. Here, what is required is calling the police. You know, police is called. It says the police are immediately called to the place where the offense has been committed. In this area, something wrong is happening. We are threatened or we are at risk, so please help. If you call to the police, that makes the offense flagrant offense because police have got information about the commission of an offense. It has become under the knowledge of the police. So that is why, in case of flagrancy, the effect of flagrancy is that there is no need of making an accusation or complaint. Okay, any other question, please? Any other question? because I know that these concepts are tricky. Flagrant, assimilated, they're a bit tricky. Please, yes. So Article 2, the last line says, where a hue and cry has been raised. A hue and cry has been raised. And at the same time, Article 20 of Article B, a cry for help has been raised. They are similar. But the difference is the time gap. You know, Article 19 of Article 2 says, after it has been committed. Line 1. After it has been committed. But Article 20 of Article B says, where the offense is being or has been committed. The difference is technical. I mean the time gap. It is past tense after it has been committed, but it is present participle. It's latent or present perfect tense. So that is the difference. I mean the time gap between the commission of an offense and the cry for help. Here, the cry for help under Article 20 of Article B, a cry for help has been raised whenever the offense is being committed or has been committed. I mean, there is a very narrow gap between the cry and the commission of the offense. But here, Article 19 of Article 2, after it has been committed, it's past. So it may be a prolonged time. The cry for help may be made a prolonged time. That's the only difference that they have. Otherwise, they are similar. Okay, that's why I said you have to make an advanced reading on these points. Okay. So now let's go to the difference. So the point that I wanted to gather on flagrant offense, assimilated cases, what a flagrant offense is that the commission of an offense has become under the knowledge of the public and the police, because police is also a member of the public. So it has become under the knowledge of the public. Everybody, many people have that information about the commission of an offense. So in such cases, Article 21 provides that in the case of offenses as defined in Article 19 and 20, proceedings may be instituted without an accusation or complaint being lodged. What do you think is the reason? Unless the offense cannot be prosecuted except upon a formal complaint. No mercy, no excuse, or no exception is offered as crimes punishable upon complaint is concerned. If a crime is, if it is a crime punishable upon complaint, still, whether it is flagrant, assimilated, what have you, still an accusation and a complaint is necessary. If the offense is a crime punishable upon complaint. But in other cases, the effect of flagrancy is that proceedings may be instituted without an accusation. Without an accusation, proceeding will be instituted. Proceedings may be instituted without an accusation or complaint being lodged, it says, unless the offense. In my opinion, the term complaint should have been deleted. Because it's already said, unless the offense cannot be prosecuted except upon formal complaint. So, it's a poor man draftsmanship, I would say. Complaint should have been deleted. And in the case of offenses as defined in Article 19 and 20, proceedings may be instituted without an accusation being lodged. It would have sufficed. So the point is, if the offense is, a flagrant offense, police will institute proceeding. Police will start investigating into the commission of an offense without an accusation. No need of accusation. It means police will not wait until somebody calls and reports and physically comes and reports about the commission of an offense, or makes an anonymous accusation like the case under Article 20. So anonymous accusation or accusation is not necessary if the offense is a flagrant offense. So police has immediately to proceed on investigation. What do you think is the justification? Why accusation is not necessary? Please.
Police has been already know the crime.
Exactly. Exactly. Police already has got information about the commission of the offense. Because we have seen the flagrancy, the nature of flagrancy. The nature of flagrancy is that the knowledge, the commission of an offense becomes under public knowledge. So police is also a member of the public. Information is abundant, it means. Information is abundant about the commission of an offense. Many people know about the commission of the offense. Many people know about the commission of an offense. So why should police wait until accusation is made? Why? Police shouldn't wait time. After all, police has an obligation to prevent the commission of offenses. Police has a duty to maintain peace and security of the public. So if an offense, if the knowledge about the commission of an offense has become under the knowledge of, the police, if police knew about the commission of an offense, why? And if police has got information about the commission of an offense, if information is abundant, why should police wait until accusation is made? That is the justification. And that one point that you shouldn't forget is it says, the last paragraph, unless the offense cannot be prosecuted except upon formal complaint. If the offense is, it means, if the offense is a crime, punishable upon complaint, even though it is a flagrant offense, then police still needs a formal complaint. Still needs formal complaint. Okay? So that crime may be crime punishable upon complaint, and it has become under the domain, the knowledge of the public. Public has witnessed. And the offender was caught in flagrant by committing that offense. Let it be. It doesn't change its nature. Still police cannot proceed to investigate unless formal complaint is made. That is what Article 21 Plan provides. So that you can understand the degree of protection that the law has given for the privacy of individuals. That is to protect the interests of individuals. As we said last time, crimes punishable upon complaints are related to, they are intrinsically related to, very closely related to the private person. So it has to be instituted. Criminal cases should be instituted only with the consent and free will of the injured person. So even though it has become under the knowledge of the public, if it is a crime punishable upon complaint, then police cannot proceed to investigate. Police still needs the complaint from the injured person or from those driving rights from the injured person. And the other effect of flagrancy is arrest without warrant is possible. Article 2, Article 21. An arrest without warrant may in such cases be made on the conditions laid down in Article 49 in the following. Okay, right now we will see what arrest means. But that what you should remember is that in case of flagrancy, it is possible to arrest a person without warrant. The rule is that under Article 49 it is provided, we will write now, see. The rule is, it is not possible for the police to make an arrest without warrant. Arrest with warrant is the rule. Arrest with warrant is the rule. Arrest without warrant is the exception. It is only in exceptional cases that police can arrest without warrant. Otherwise, the rule is that arrest should be made with a warrant. Arrest without warrant is the exception. So one of the exceptions in which arrest can be made without warrant is whenever the offense is a flagrant offense. If the offense is a flagrant offense, arrest without warrant will be possible. Arrest without warrant will be possible. Then what is arrest? What do we mean whenever we say arrest with warrant or arrest without warrant? We will see right now. Okay, any question? Let's proceed on police investigation. This moment, police has received information. We have considered what our accusation is made. And we have also considered that in case of flagrancy, accusation is not necessary. case of flagrant accusation is not necessary, except that the offense is punishable upon complaint. Okay, so police has that information, either through accusation or because the offense is flagrant and the knowledge about the commission of an offense is under public domain, so that police has that information because it's a flagrant offense. So whether it's a flagrant or non-flagrant offense, assume police have that information. Then the next step is investigation. Investigating into the commission of an offense. So what activities are involved in the investigation process, in the police investigation process? But police investigation is nothing but it's the gathering of evidence about the commission of an offense. So we will see the steps that what the police do in the police investigation process is gathering of evidence. You know, gathering relevant information about the commission of an offense. But whenever the police gathers information, in the process of gathering of evidence, police has to follow some, requirements, some standards. We will see that. Article 22. Whenever the police know or suspect that an offense has been committed, they shall proceed to investigate in accordance with the provisions of this chapter. Article 23. Duty of police to investigate. Investigating police officers shall carry out their duties under this chapter, notwithstanding that they are of opinion that the accusation, complaint or information they might have received is open to doubt. So what it says is, the police has gathered information, and the formal complaint or accusation following the procedures of the law has been made. So even though the information that the police received is open to doubt, police is duty bound to proceed on investigation. Police is duty bound to proceed on investigation, as long as police gets information. And Article 24, recording of statements. Yes, please. And it is open to doubt. It means, the person has genuinely made information, accusation. Has genuinely made. I mean, he doesn't have intention to make false complaint. In order to operate the justice system, you have heard something, you have got information about the commission of an offense, and you may not have full information about the commission of an offense, for example, but you have got information about the commission of an offense. And you were genuinely concerned about the peace and security of your people, your fellow. So you reported the commission of that offense. And police recorded genuinely, and it has checked. And you are made genuinely, and you don't have any intention of making false accusation. Okay? So in the end, after police receiving that information, police may find it to be something open to doubt. Police may say, is this offense actually committed? It's not because you made a false accusation. Sorry? But it has to investigate. Finally, whenever there is no sufficient information, we will see that the consequence. After receiving that information, if there is no sufficient evidence, there is procedure for that. But what the law wants to order the police is that even though the information received by the police is open to doubt, police has to investigate. Because that information is made by a genuine citizen. I want to protect my public. I want to protect my people. I want peace and security to prevail in this country, in my society. So, due to my genuine concern, I report to the police. But due to a number of reasons, like due to the manner that I gave that information to the police, or due to the fact that the information that I gave to the police is incomplete, okay? Police may find that the information received is open to doubt. In such cases, let it be. As long as a genuine accusation is made, police has to proceed on investigation. So if it is not sufficient, if there is no sufficient evidence, then there is a procedure and so on. But what Article 23 provides is, police has a duty to investigate. Okay? That's enough? Is it clear? Any other question? Recording of the settlement, Article 24. After having recorded an accusation or complaint in the manner laid down in Article 14, The investigating police officer shall elicit from the person making the accusation or complaint all relevant facts and dates, the names or description of the offender, the names and address of principal witness, and all other evidence which may be available and shall record them. So you see, the police will record information. I know whenever you make an accusation or complaint, police will gather. That's why I said police investigation process is all about gathering of evidence. Okay? So one of the parts of police investigation is recording statement. Recording statement from the person making an accusation or complaint. So every relevant information has to be recorded by the police. Like for example, the names or description of the offender. So police will ask you whenever you make an accusation, the name of the offender he will ask you. The name of the offender. So you may know him or not. Okay? If you know the name of the offender, you will tell the police. Otherwise, you don't know. If you don't know, that's not a crime. Then the names and address of principal witnesses who were around the vicinity of the scene of the offense. So police will ask you, have you seen people around the commission of the offense who were there? Because they are witnesses. Then that person making an accusation may say, were there. Mr. X, Mr. Y, Mr. Z were around the commission of an offense. So from now onwards, it is up to you to be at the scene of the offense. If you are around the scene of the offense, then you will be obviously a witness. Okay? Because the person making an accusation may tell to the police that Mr. X, Mr. Y, Mr. Z were around the offense. They are witnessed. And all other evidence which may be available and shall record them, it says. All other, like for example, the person making an accusation may say, oh, I don't know the name of the person. I don't know the name of the offender, but he's tall. And he was in a red shirt, for example, he may say. You know? Like any information about the person. The police has to record that. The time when the offense was committed. At what time was the offense committed? The time. He has to tell every relevant information. Okay? And the degree of participation of the offense. If more than one person has involved in the commission of an offense, for example. Right? Okay? Then, Article 25, summoning of accused or suspected person, it says. Okay, very quickly read Article 25. Summons where the investigating police officer has reason to believe that a person has committed an offense, he may by written summons require such person to appear before him. Okay? So, after analyzing the information given by the person making an accusation, so analyzing the information given by the person making an accusation, and police may analyze that, or police may understand that the offense has been committed by Mr. X. Okay? So the information gathered by the police directed him to believe that the offense has been committed by Mr. X. Because of the information that he gathered. Maybe the information that the person making an accusation, during the accusation, the person making an accusation said Mr. X has committed. And the police cross-checked it with other evidence. The police cross-checked it by using his profession. He's a professional. By using his investigative techniques, and he analyzed the evidence, the information given by the accusation, the accuser, and by all circumstantial evidence after gathering, and whenever the police analyzes, Mr. X has police believed. It is not, the court hasn't decided that Mr. X has committed it. But if the police right at that moment, the police may believe that, Mr. X might have committed the offense, and Mr. X has committed the offense, you have to bring in, make an investigation. So in such cases, police will request that person to appear before a police station through summons. So where the investigating police, Article 25, summoning of accused or suspected person, where the investigating police officer has reason to believe that a person has committed an offense, he may, by written summons, require such person to appear before him. By written summons. So summons is something, documents. You can find it in the final schedule of this code as the formality of summons. But it is a document, a formal document, issued by the police. It is a document issued by police. It is the police that issues the summons. Mind you, it is different from warrant, court warrant. You will see that. It is different. This summons is a document issued by the police. Okay? So that says, what does that summons say? That summons says, generally requires Mr. X to appear before the police station, before the police, because he has been suspected of committing an offense. Committing an offense. Okay? But the question is, look, it says, he may, by written summons, require such person to appear before him. So the term may, indicates some sort of discretion, isn't it? Discretion. Why? Why may? Why not shall? Why not shall? Why not shall? Or why not must? Or why not has to? These obligatory terms. Why it used may? So the point is, there are some instances whereby summons is not necessary, it means. In some instances, summons may not be necessary. Gather the evidence, but summons may not be necessary. What are such instances? So, like flagrant offense. Flagrant. Dangerous vagrancy. Have you heard this kind of crime? Yes, dangerous vagrancy. In such cases, there is no formality requirement. That person will be forced, the person who is suspected to be vagrant will be forced to appear to the police station. So there is no such requirement of summons. Requirement of summons. Otherwise, summons is necessary. Summons is necessary. Okay? So this summons is a document issued by the police requiring a person who is suspected of committing an offense to come to the police station. Then, the person, Article 26, the person, we will see, I'll give you time to read. But whenever you receive summons from the police, your reaction may be different. There are some people, after looking at this, assuming that this is an arrest, well, this is summons, this is summons. Then whenever the police gives him summons, he may throw away. Some people even may tear it out. Okay? Or some people may say, okay, all right, I will go. And there are some law-abiding citizens. Okay? So, what is the importance of arrest in such cases? We will see. Okay, let me read please Article 26. Article 26. When the accused or suspect hasn't been arrested and the offense is such as to justify arrest, or where the person summoned under Article 25 fails to appear, the investigating police officer shall take such steps as are necessary to effect his arrest. So we will see how arrest is made and the requirements. And so Article 2, where the arrest cannot be made without warrant, the investigating police officer shall apply to the court for a warrant of arrest in accordance with Provisions 53. So this takes us to consider kinds of arrest. Arrest either with warrant or without warrant. That is why sub-article and Article 26 says, where the accused or suspect hasn't been arrested and the offense is such as to justify arrest. There are some offenses which do not justify arrest. Like, for example, the flagrant offense that I told you. And what if the offense is a flagrant offense? there is no process. Simply the person will be brought to justice. We'll see that under the umbrella of kinds of arrest. Or where the person, someone under Article 25 fails to appear, the investigating police officer shall take such steps as are necessary to effect his arrest. So, arrest will be made. You are summoned to appear before the police. You are summoned. As summons is a document issued by the police. So you may refuse. As I said, there are some people who are not, law-abiding citizens. They don't want to, obey the orders of the police. So I don't want to come. In such cases, police is not allowed. Police is not allowed to use force or any other measure. He is not allowed to take any measure. Because Article 26, subarticle 1 says, the investigating police officer shall take such steps as are necessary to effect his arrest. So if the person fails to appear to the police station, then the police should take next steps that are necessary to effect his arrest. As I said, arrest can be made either with warrant or without warrant. So if the offense is not a flagrant offense, then police needs, and also, in fact, there are some kinds of offenses that can be arrested, in which a person may be arrested without a warrant. Except in such cases, arrest with warrant is the rule. So if a person refuses to obey by the summons, then police has to take measures that are necessary to effect his arrest. So what the police should do is, police should go to the court to get court warrant. Arrest warrant is necessary. So by using arrest warrant, when you have refused summons, you have refused to obey the summons, then the police immediately went to the court and got that arrest warrant. So in such cases, by using arrest warrant, police can arrest you. And you cannot, in such cases, it is order of the court. You cannot disobey or you cannot ignore, in such cases, the orders of the court warrant. Okay? So you have to be. Then police is allowed in such cases to use reasonable force. If you resist the warrant, then it is up to you. Police is allowed to use in such cases proportionate force, reasonable force, because you have to be brought before justice. You have to cooperate with the justice. All right? So, obviously, as we consider, if the offense is a flagrant offense, as we said, then arrest without warrant is possible. That is one instance. But let's consider arrest in what circumstances arrest without warrant is possible, under what circumstances arrest without warrant is possible. What do we mean whenever we say arrest is the rule, arrest with warrant is the rule? Arrest with warrant is the rule. Arrest without warrant is the exception. It is only in exceptional cases that arrest without warrant is possible. Otherwise, arrest has to be made always with a warrant. Warrant is different from summons. Arrest warrant is different from summons because arrest warrant is issued by the court, whereas summons is issued by police. If you resist summons, police cannot use force. Instead, police should resort to getting arrest warrant. But if you resist arrest warrant, then police can use reasonable force. We will see it in detail. Okay, read Article 49. the person was summoned and he has appealed to the police station. Then can we say that he is arrested? He's saying, your name? Barakat is saying yes. Any other person? Barakat is saying. The question is, he asked me, your name? Huh? Habib. Okay, Habib asked, Habib said, that person was the person who was suspected of committing an offense. Police gathered information, and police reasonably thought or believed that X has committed an offense. As a result, police issued summons and requested him to come to the police. And he obeyed the summons and he appealed to the police. Then can we say that he is arrested? Can we say that X is arrested? Because he has obeyed the summons. He has respectfully, peacefully came to the police. And in that case, can we say that he is arrested? That is his question, Habib's question. And Barakat is saying, you cannot say that he is arrested. What do you think? Please. Arrest presupposes using of force. That's your point, isn't it? Arrest presupposes using of force. Police hasn't used the force, so that we cannot say it is an arrest. Please, yes. To be arrested, yes, it is an arrest, he said. So impliedly, he's saying that there are some offenses which do not require an arrest. Isn't it? Please, ladies are encouraged. Yes. Sorry, would you repeat it? Yeah. Without the warrant? Yeah.
He is arrested.
Yeah.
As soon as he came to the police station.
Yeah.
But if the offense not arrested,
Yeah,
not arrested without the warrant,
Yeah.
he is arrested.
Okay. In that case, arrest is necessary, it means. Okay, very good. So she's saying if the offense if arrest can be effected without warrant, then we cannot say that there is an arrest. But otherwise, if arresting warrant is needed in respect of the offense, then we can say that there is an arrest. Okay, very good points that I'm receiving. But what do you understand by the term arrest? The question. Because you have strengthened your position. He's saying using force and making person under the control of the police. So use of force is central according to question. Okay? Another one? Please.
Detain someone under custody.
Oh, he brought another concept. Detention. This is totally, related but different concept than what I understand is you are. It's good that you are making reading. Okay? It's detaining a person. It's an arrest. Okay? Okay, another point. Okay. Arrest, what you should understand is making a person under the control of the police or the law enforcement authorities by whatever means. The person may be under the control of the police by using summons, because that person obeyed the request of the police. You obeyed the summons and he came to the police station, then he is under arrest. At that time onwards, he is under arrest. He is not a law-abiding citizen. And he teared down the paper, the summons. As a result, police resorted to an arrest warrant. And he was forcefully arrested by using an arrest warrant. In such cases, he became under arrest. The end point or the final outcome is arrest. So arrest can be effected either with the summons or by using warrant. Or even if the offense is, a flagrant offense, warrant may not be necessary in some cases, isn't it? So he was, caught while committing the offense. He was found committing an offense. Police reached in, he was grabbed. And he was brought to the police. Immediately, police investigation will continue without an accusation or warrant, accusation of complaint, as we said. In fact, I prefer to use accusation because complaint is not necessary. So he has become under the control of the police for investigation. In that case, it is also an arrest. An arrest. Okay? So arrest may be made either by using force, by using arrest warrant. Even by the way, in case of arrest warrant, whenever an arrest warrant is brought before you, first you have tipped down this summons. And whenever a court warrant came to you, an arrest warrant came to you, then you may peacefully, subdue or obey that warrant. Okay? Police may not necessarily use force. But sometimes you may resist even the warrant. In this case, police may use force. So, finally, you may be brought to the police station for questioning. So that is an arrest. So the point is, if a person becomes under the custody of the police for interrogation, and the next steps, then we say that person is arrested. Now is the point clear now? Please, yes. Then police will be relieved. And police will not be forced to the court. Look, someone's police on you. You should argue, man of Lensa. You are busy on just police tabia karbash. The normal assessment for the police tabia. Okay? And in such way something someone's police. Okay? Then I serve you that someone's. I tell you someone's with a police tabia, then you are arrested. A warrant not by the aggressive. Exactly. Sorry? Yes, someone's a latakabella. Someone's a latakabella. I exception man like Balma. Exception me Baloko, your rule. Then, whenever you derogate that rule, then you say exception. Application of warrant. Yeah, someone's a someone's exception now. I don't know. And then you state the measure of police someone's here. Someone's obey Kadarash, as I told them, obey Kadarash, where the warrant here. Warrant them, Mescal, arrest warrant is a rule, arrest without warrant is exception. Never availability. Okay, in Yakabam solution, Madame Cabrera, Madame Lumu. So now, okay. Anyhow, if a person obeys the summons, then there is no need of arrest warrant and be pardoned as well. Police are interrogation. Someone's ignore that arrest warrant, take it as well. Unless the exceptional warrant must be good, arrest warrant as well. So sometimes, what police do, but police was grab the direct, but it's against our dignity and we don't want it. Someone's is that true? You may tear it down, but I don't advise you to do that. Okay? But even when you tear it down, then police cannot use force, as I said. But is it in practice? It's not totally. And then someone's police. It's very difficult in practice. Even by using summons, what the law says, if you respect that summons, then you don't have the right not to be even touched by the police. Then in practice, what they do? Are they doing that? Sometimes there is that hidden motive. So, the police said, even the government wants it, sometimes intentionally. government sometimes intentionally do this. In the end you may be found innocent. ግን የናንተ በኋላ ላይ ንጹህ መሆናችሁ ነው የሚወራው በደንብ አቴንሽን የሚሰጠው ወይስ በፖሊስ መያዛችሁ ነው? በፖሊስ መያዛችሁ። Nobody notice. ይሄን ነገር ማንም አያስተውልም። ምን በኋላ ላይ ነፃ ሊሆን ይችላል እና you don't worry. But you have to worry about the procedure matters. Procedure matters. Okay? ስለዚህ ብዙ ጊዜ ሬዚስት ለማድረግ እንኳን ያልፈለጋችሁ እሺ ያላችሁ ስራ ፖሊስ ይዛችሁ አወቁ። I remember a certain university instructor. He was teaching in the classroom. Okay? He was teaching in the classroom and police came. Imagine even the process of summons. How is someone's affected? The criminal procedure code doesn't have detailed provisions about it. But there are international standards. Someone's who fake የሚደረግ በምን ሰዓት ነው? ስንት ሰዓት ላይ ነው? ከማን ጋር ሆናችሁ ነው? እንዴ sometimes it may be against our dignity bro. ይሄ መምህር ያስተማረ ነው፣ ተማሪዎችን ያስተማረ ነው። ፕላን እንደኔ አሁን እንደዚህ እንዳለው imagine police መጥቶ አንገቴን አንቆ ይወስደኝ። He was teaching and police came. Even he hasn't asked the students an excuse, the police. He immediately entered into the class and he showed that someone said, think of the dignity of that instructor. Secondly, even first you have to think of, students should be respected, isn't it? The students should be respected. The teaching learning process should be respected. They have come here just to get something, isn't it? So in front of his students, the teacher is the father of the students, isn't it? And abat no remember. Imagine being the tamarochu just silaachwal nde. So even procedure አይከበርም። በልጆቹ ፊት አንድ አባት በልጆቹን እያጫወተ በልጆቹ ፊት ድንገት ሰሞን ይዞ መጥቶ አንቆ ሲወስድ ልጆቹ ላይ የሚፈጠረው ነገር ምንድን ነው? ምን አይነት አመለካከት ምን አይነት ይዘው ሰላሞች የሚያደርጉት? Okay, so there are very serious problems in the implementation of summons. አረ ሄዳለሁ በቃ ልቀቅ የምትሉት ራሱ አይለቃቸው እና because there is something bad motive at the back. Okay, so